Greetings, everybody. This is Brian Terrian here today with Barbara Mountain. How are you, Barb?
I'm doing great, thank you.
Good. Thanks for coming out and spending some time with us. I'm glad that we're going to be able to do this. The thing that really intrigues me, Barb, about your experience that will be of value to our members is that, unlike anybody I know in the industry, you've worked in different aspects. That's been pretty cool. You spent time working with the Social Security Administration. Then you've worked with long-term disability carriers. And now you're working with Doherty, Kella, and Keene as a direct-to-consumer Social Security Disability Representation Group in the Boston area. So you've seen all different angles of disability applicants going through the approval process. You've seen the mistakes. You've seen what works and what doesn't work. And so we're going to see if we can get you to spill your guts and tell us all today.
Great, sounds good.
So anyway, congratulations on a nice, well-rounded career. And so let's get into it. What we're going to cover today, for those of you listening, is we're going to cover really the common causes of why claims get denied. High 70% of initial applications get denied, and there's some steps that you can do to avoid that. We're going to talk about disability representatives, different types of them, how you find good ones, how you weed out the ones that likely would not be of your best interest to hire for your claim. Really how representatives can increase your odds of getting approved, and what else are we going to talk about today? The value they add. Does a representative have to be local? I've got a whole list of questions here, so why don't we just dig right into it and get started. All right?
Sounds great.
The first thing I want to go through with you is this term that we've kind of coined here, a full-service disability representative, Barb, which is really there's two different types for the audience that are listening out there. What a full-service representative does is they really do all of the paperwork for you. And at the initial application phase, there's, 100 and something forms somebody's going to fill out?
Yeah, there's a good number of pieces of paperwork and questions that have to be answered.
Yeah. So a full-service representative will do that for you. Of course, you could do it on your own. But let's talk about full-service representation. And unlike small firms that if you go to them and say, I haven't applied yet, they might say, well, go ahead and apply, do it on your own, see if you get approved, if you don't, come back. So what can you share with us about the difference, and why have representatives gone this way? It seems like a whole lot of extra work.
Well, a lot of the smaller companies or local companies you're talking about that will tell you to go file on your own and come back if you've been denied, they're looking at it from a perspective of saying, we want to deal with it when you're getting to that hearings level, when we're going to go represent you in front of a judge, and once you get awarded, we're going to get a piece of the back due benefits that you're paid. They're thinking, if you file on your own and you're awarded on your own, that's great. It was less work for me. I wasn't going to get paid much anyways. What a full-service rep, though, is thinking is, and knows, is they help you with that initial application. They're going to increase your chances of getting awarded, if not at the initial level, later on, because they're going to start the claim off on the right foot. When you're answering all of those questions, it's really important to answer them the right way. Vocabulary is very important, and to a layperson or a person who's just kind of talking about their disability, they don't really know what Social Security is looking for. And what Social Security is really looking for is for you to say how your disability is affecting your ability to work. So you can talk all about the pain and how much pain you're in on an everyday basis, but if you're not kind of correlating that back to how is that pain affecting your ability to go to the office every day, or to talk on the phone, or to sit, or your attention span, it's not helping the case. So having a full-service rep who's willing to start from day one may get you awarded at the initial level, certainly will increase your chances, but will also increase your chances even later on if you have to go to that hearings level, because they're going to start it off that claim the right way with the questions being answered appropriately.
Mm-hmm. Okay, so it's really the wording is what I'm hearing, and I gather you learned that from the 7 years you spent with Social Security. If you saw claims that would fly through, that they likely met that criteria. Is that?
Absolutely.
Okay.
Yep. You know, people just they aren't understanding. They're talking, and as you know, as you would expect, they're talking so much about the disability. They're forgetting the parts you kind of got to correlate how that's affecting the ability to do work in the national economy. You know, it's a subtle thing, but it's an important thing. And people can say things that they didn't intend. They might say, you know, my doctor says I can do light duty. Well, what a doctor interprets as light duty and what Social Security, according to vocational grids, interpret as light duty are very different. So you have to be really careful with how you throw out those terms because that could dramatically affect your decision.
You know, it's interesting. It's really... I guess the best way to put it is it's not natural for people to explain why they can't work because we are built and trained to sell ourselves, why we can work, you know?
Right. Exactly.
So you're talking yourself out of a job is really what the deal is here. What are some of the other steps that people do? And I direct this question in this area. A lot of people... members that are going through the approval process, certainly they're interested in increasing their odds, but people that are sick and just don't either have the mental capacity or the energy to do it, are there other key things or heavy lifting that representatives do that you could share with us that make this process easier?
Well, what they should be doing is filling out all of the paperwork for the person, whether they're doing it by phone. Typically it's done by phone. They'll ask the questions and you have to answer it, but they're the ones that are going to complete, you know, the pages and pages of information. Gather it all together, send it to the person to, you know, clearly marking where they have to sign. The idea behind it is they're taking all of the work out of the process while giving that claimant the best representation possible. They're also going to make sure, you know, that they're getting all the communication from Social Security. So if new forms are needed, you know, if there's a question that needs to be answered, they're going to make sure that's done and it's done timely. You know, if a claim is denied, they're going to make sure that appeal is filed and filed within the time frames. So they're kind of staying on top of everything, making sure everything's done appropriately, handling all those logistics so you really can concentrate on getting better or, you know, whatever you're going through in order to help your own personal situation and not kind of have to deal with the headaches that Social Security is giving you.
And so could you set the expectations for somebody that is going to be working with a full-service representative? They still do have some obligations, correct? Like they do need to authorize forms so that they can do the work.
Exactly. They will need to, you know, sign a form, basically authorizing the representative to become the representative. They still need to sign authorizations to release information. Social Security can go get the medical records. So there's forms they definitely need to sign. They do need to, you know, respond and answer honestly and straightforward so the representative can best represent them in front of Social Security. If there's any new medical evidence, new doctors, new important tests that's happened, they make sure they keep that representative updated on that. That's really the most important thing is that if there's new evidence or new information they think would be important, that they are communicating that so the representative has that and can submit that to Social Security.
Okay. So my understanding is that the way that a representative will increase somebody's odds, if they're a good full service, is really wordsmithing the application and communicating how somebody specifically can't work and has limitations.
Right, and ensuring that the medical records are complete. It's really easy to forget a doctor, to forget a hospital, you know, to forget some medication. They're going to make sure you know, talking with the individual that they have all that information and that they get that medical information. At the initial application, Social Security will go out and get the medical records. However, there isn't a guarantee that they're getting everything, that they're following up, making sure that they have everything. Your representative is going to make sure that Social Security, or they should be making sure, has all that information right from the beginning. And that's extremely important and also is going to make your decision a whole lot quicker. If Social Security can start working the claim immediately and doesn't have to wait that time to get the information back from doctors and hospitals, that's going to increase your chances too. That's a huge benefit right there.
Okay. Let's roll it forward a little bit for somebody that has already applied. So we've talked about those that haven't applied. We're going to talk about those that have already applied, and they're waiting. Okay.
Mm-hmm.
Now the wait to get approved or wait for a decision at the initial level varies. I don't know if you have any.
It's about 3 to 6 months on average.
3 to 6 months. Okay.
Right.
So if somebody's in that 3 to 6 months range, and they're just like, I'm really considering using a representative. What value could a representative add at this stage, Barb?
Well, once the claim has already been submitted at the initial level, it's up to Social Security to make that medical decision once they have the application. So if the initial application has already been filed, it's already supplied, the medical information and medical listings for Social Security to go and collect that, there's really not a whole lot they can do at that point. They could potentially, ask how did you answer these questions and maybe submit some supplemental information. But for the most part, if you've already submitted it at Social Security and, you think you've answered things, to the best of your ability, you've listed all your doctors and hospitals, it could just be best at that point, wait till the decision comes back, and then at that point, if it's been denied, get a vendor involved. There's not too much that they can affect once that initial application is in.
Pending that it's done correctly. Now, let me also say this. A lot of people wonder if they've done it right. So let's say that they haven't listed all their conditions, or they don't have all their medical records, or all their medications, or something's happened in that 3 to 6 month period that could influence the decision. Can an impact be made?
Well, it can. You definitely can get in touch with that disability examiner and tell them there's more medical evidence that you want to add to it, and they could write up an addendum, maybe documenting some additional information about the condition, and then including the new medical evidence, and that certainly will supplement the claim and could affect it, as long as you get there and you get that done in time. So it's definitely possible. Also, the person, if you do hire someone while that initial claim is pending, they could already start delving into that case, preparing it for appeal, if they think the claim is going to be denied. So there is that potential that once it's there, that having a representative come in, they could have an impact. The most important piece, though, I'd say, is that initial application and answering the questions right off the bat. Because if they did say something that hurts their case, that has to be overcome, for example, mentioning something about my doctor says I can do light duty, not really understanding what that means, or a claimant that's on long-term disability saying I'm filing because my insurance company is making me. That they may not mean I don't think I'm disabled and I shouldn't file. They were just maybe stating a fact. Those are things that have to be overcome later, and having them up front just makes the case a little more difficult down the road.
Okay. Barb, let's talk about back benefits. Maybe you could first of all just give us a quick explanation of what one is entitled to for back benefits, and then we can kind of move on to talking about onset dates and how those could be properly spotted.
Sure. Whenever you file for disability, you're going to allege a date of disability, the date you could no longer work. If Social Security finds you disabled as of that date, you have to wait 5 full calendar months before your date of entitlement, and the date of entitlement would mean the first month you're due a payment. So if you were disabled on March 15th, your waiting period would be April, May, June, July, and August. September is the first month you're due a check. That's your date of entitlement. Now, Social Security can pay back 12 months from the date you file. So if you waited to file, you were disabled, you waited a little while, you wanted to see if you were going to get better, you eventually find out that you have to file. You want to be sure that you file at least within 17 months from the date of disability. And I say 17 months because that's the 12-month waiting period, that's the 12 months they can pay back in retro benefits plus the 5-month waiting period. If you wait longer than 17 months from your date of disability and you're eventually found to be disabled as of the original date of onset, you will be leaving some money out there that you won't be allowed to be paid because Social Security can only pay you back 12 months from the date you file.
So if you're over 17 months, you could be leaving money on the table.
Exactly.
Okay.
So you want to make sure you file within 17 months of that initial date of disability.
All right. Now, gather my thoughts here. So if somebody has intermittent work attempts, failed work attempts,
right,
and they go to apply. For example, let's say that they apply today, but they really haven't been able to work consistently for the last year. can you give us like a general statement of what might be possible for somebody to adjust their onset date? Because
Sure.
it could be today, but it might not be.
Right. That's a great question. That's one of the big reasons why I'm very pro getting someone to help you when you're filing for disability benefits, because when you fill out that application for Social Security, it's going to ask you what was your date of onset, and it's going to say when was the date you could no longer work. And for a lot of people, it's not a drop-dead date. It just didn't all of a sudden occur on this date, and I never worked from this date forward. For a lot of people, it's that intermittent disability. It came on maybe slowly. It affected work. They were in and out of work. If you don't have somebody telling you what dates to put in, you're probably going to put the most recent date you were out of work. And that's not always what you have to do. You can sometimes move that onset date back. And the way to do that is something called an unsuccessful work attempt. And that's a Social Security term. And basically what it means is if you were out of work for at least 30 days at one point in time, you had to have a break of 30 days. You went back to work, but it wasn't successful, and that work lasted for less than 6 months. If it ended because of the disability, there is a potential you can move that onset date back to that original time you went out. So if the work period, it's definitely can be moved back if the work period was less than 3 months. If it's between 3 and 6 months long, you kind of have to do a little evaluation of how much you were working and what was going on there. It's more paperwork that needs to be done, but it definitely can be done and should be looked at to see if you can move that onset date back before you went back to work and tried out for that preliminary period that just didn't happen.
Okay, so I want to make sure I get this. If somebody is working out of work for 30 or more days and then goes back to work for less than 6 months, they could pinpoint their onset date at the beginning of that 30-day period?
Exactly, as long as the work ended because of the disability. And that would be called an unsuccessful work attempt, and there is some additional paperwork that needs to be done to document that unsuccessful work.
Yeah. So if sometime within the last 17 months that this happened, it would really make sense for somebody to target that correct onset date, because every month they could pick up is extra money, right?
Absolutely. Absolutely. It's huge. And not only is it extra money, but it also, the earlier your date of entitlement, the earlier your Medicare will start. You get a Medicare 2 years after your date of entitlement. So if you can get that date of entitlement to move back by 4 or 5 months, that's going to move up your Medicare entitlement date.
Oh, great point. That's a great point.
Yeah. So the date of disability is extremely important. It's probably the most important question on the application is to get that date of disability right, because you want to get benefits as early as possible.
Okay, I want to make sure I get this part right. So your 24 months that you have to wait for Medicare is 24 months from the onset date of your disability?
No, it's from your date of entitlement. From
your date of entitlement.
Right, which is going to be 5 full calendar months from your date of disability. So that person who is disabled in March 15th, his date of entitlement is going to be September of 2010, so Medicare starts in September of 2012, not the March when they were actually disabled.
Okay. I have been led to believe, and thank you for clarifying this, that it was 24 months after you were approved.
No, actually, you could have been approved. It might have taken them 2 years to approve your claim. Your Medicare may start right up as soon as it's approved. You're eligible for Medicare immediately.
Wow, this is great news.
Yeah, not the approval date. It's all based on the date of entitlement.
Okay, so you got to get that date of entitlement correct. You got to lock it in.
Right.
Okay. Awesome. All right. Yeah, and, so 17 months minus 5, 12 months. I mean, that's 12. There's some people I've known that have gotten back benefit checks for over $20,000.
Exactly. Sometimes, you don't want it to be the largest. You don't really want a large retro, because what that means is it took Social Security a long time to approve you, for the most part. It could take 2-3 years to get awarded, and they find you disabled right back to the beginning. Well, then you're owed about 2.5 years of back benefits, and that's why you have the large retro. Ideally, if you get awarded, quickly, so the benefits can come in right away, and you don't have all those years when you're waiting for this income.
Or you've waited to apply.
Exactly. Or you've waited to apply.
Yeah. Okay. So let's see if you can, as best you can from your position, your professional position, if you could provide us with some some questions, I guess, where I'm going is attorney selection questions. We get an idea why to look for a full-service representative and what some of the value of it is. But, I guess I'm going to start with this. If somebody hasn't applied, most people are of the mindset to say, well, I want to find somebody that's local. And so can you give us your take on that? Do they need to be local?
Sure. You absolutely don't need to have somebody local. Because the process with Social Security isn't something where you need to be face-to-face, when you're dealing with Social Security, you're always dealing either phone or email. It's not a face-to-face process unless you get to that hearings level. And when you're dealing with a representative, everything can, again, be done by phone. As long as you can communicate with that attorney, that's fine. So you don't have to have a legal presence. You may want it, but you don't have to have it. The most important thing, I believe, and I've said this since I worked for Social Security day one, is that you hire someone that only does Social Security law. It really is a niche market, and you want someone where that's their full attention, and they've seen a little bit of everything, and they know what they need to do. Another point that I might make about using a local representative versus somebody, just somebody you like who represents people nationally, is a company that represents nationally will tend to, work with judges all over the country. Wherever you happen to be and the judge you're assigned, they're going to work with that judge. When you work with a local attorney, they tend to work with the same judges over and over again. Now, you may think on the plus side, well, they know that judge, maybe they know how to present a case to them, and there's absolutely truth to that. But there's also the truth to the fact that the local attorney works with this judge so often on so many cases, they have to stay on good terms with that judge. They're not necessarily going to press the envelope or push something or be confrontational in situations where maybe they need to be, because they have to stay in good standing. They have to see this judge every single day. This is their livelihood. When you deal with a representative who represents nationally, they don't have that fear. They're going to challenge a judge if they need to, and they're going to push every case as far as they possibly can to get that claim awarded. So there's pros and cons to both, but I don't think you should limit your search to thinking you just need local. I don't think there's any real benefit in doing that. I think as long as you get the right representative, they can be located anywhere.
That's a good point. Never thought of that. Mm-hmm. Yeah, made me think of the Joe Pesci movie where he came in from out of town and he's defending the two youths.
Mm-hmm. That's right.
Yeah. Very good point. So as far as a representative being specific in this area, do they need to look for, like, if there's a certain size of representative or case volume or that is important? If somebody specializes in this and they do 5 cases a month, is that enough to be good, or is 25 or 30 better, or any take on that?
I don't think that volume necessarily is a good judge. I think if all they do is Social Security law and this is their livelihood, you can assume that, they've seen a good number of cases. You might want to ask how many years they've been in practice. I mean, how many years have they been doing this? Mm-hmm. That can certainly be helpful. I'd ask them questions about your case specifically. What do you think is the most important facts about my case in order to get it awarded? What do you think potentially could hurt my case? I'd ask questions like that. I think are more important in evaluating a representative. Other things you should ask is, what is my role in this? What do you expect from me, and what should I expect from you? I think communication is the most important tool in everything, and when there's no exception to that when selecting a representative. So you want to be very clear from the front. What do they expect from you? What do you expect from them? How will the communication go? That can always be a sticking point with attorneys, and making sure that you're updated as often as you feel you should be and that you can get in touch with that attorney. Those are really important things to know. I think those are probably just as important as everything else when you're having that initial conversation deciding who you're going to use.
That's one of the number one complaints that we get is related to that, that we see, is that they're really most, I'll make a very general statement here. Mm-hmm. A lot of attorneys that do practice this work, you don't have to be, you can be a non-attorney, but a lot of attorneys are attorneys, mm-hmm. and their business practices aren't always in tune with people's expectations, in that people think that they can always be in touch with their attorney, and that's not the case. So your point that you brought up, which is a great one, is you're suggesting that they establish an understanding of what an appropriate communication plan would be, correct?
Definitely. No, ask them, how often are you going to update me on what's going on? When do you expect I should hear something? When should I expect, you'll be doing something? Because that's a lot of it. I think when you're sitting back on the other end, you're wondering, what are they doing? Are they working on my case right now? What's happening? Is it just sitting out there? So you should be prepped up front. At the initial level, you should be told, once you submit that application and we've submitted that medical evidence, if there's no new medical evidence that comes down the road, all we can do is sit and wait. There's really nothing your representative can be doing at that point, and they should also give you guidelines on how long you should expect to wait. When will they follow up? Because there should be a follow-up plan. I mean, you don't just allow Social Security to stay out there forever. There should be a point in time, whether that be at 3 months, they're going to do a check-in to see what's going on and then get back to you. Those are important things for you to know because obviously this is your life. And so you want to know and have some assurance that everything's progressing the way it should and that you're going to be updated so you're not just sitting out there wondering what's happening.
Mm-hmm. And there are people that certainly believe that once they retain a representative that they have the right to call in frequently. And I have my opinion about that, but I think people that are going to call too much are going to create challenges in their working relationship. But I was curious what you could share with us for advice in that area.
Well, again, I think that comes back to communicating, how often makes sense. Because you're right. If you're calling every day, there's no new information to give you, and all you're doing is really taking away the time, from some other case that representative might need to work on. However, at the same time, I think it's important that you're able to get in touch with who you want to, if you have something important to share. Another question to ask when you're looking for who's going to represent you is, do you use voicemail? A lot of companies use voicemail out there. Might be hard to find any that don't, but some don't. I can tell you that the company I work for, Doherty Chelakeen, we don't use voicemail. And we don't use it for a reason because we don't like it. We want you to reach a person. So anytime you call our office, you're going to have a person who's going to get you the answer that you need. That's a good question that you can ask. But you do, on the other side, you have to have some perspective and recognize that there are certain times when you're just waiting for Social Security to act, and Social Security is not speedy. They're very slow, and sadly, they're getting slower. Right now, it's been the hearings level is where everything is just slowed down to a crawl, and it's been that way for years and years and years. But unfortunately, given the economy, Social Security is being inundated with new claims at the initial level. Last year, they had 3.3 million people file for disability benefits at the initial level. They are not staffed appropriately for that. And so what we're going to start seeing is that initial level claims are going to start taking longer and longer because more claims are coming in and they actually have less bodies to do the work than they did before. So there's got to be a recognition there that once everything's been submitted and everything's in there, that it is a waiting game. And you are going to have to wait. And there is going to be an appropriate time to follow up, but there are going to be months in which nothing's happening.
So that's an interesting figure. The last I heard, it was around 2.6 million, so it's up 700,000.
Exactly. It's gone up dramatically.
That's huge. Yeah. Okay. Well, you've shared some really good tips here. Let's talk about fees for a minute. There's a pretty general understanding of the fee structure that's out there for Social Security. Can you share with the audience, Barb, what one can expect to pay for a Social Security representative?
All right. So you're always going to ask the representative, what is your fee? 95% of everybody in this business has the same fee, and it's called the standard fee agreement. And the reason why everyone has the same amount is because Social Security must approve any fee charged by a representative to represent a claimant for Social Security. They're not allowed to go out and just dictate whatever they want. It has to be approved by Social Security. And so that standard fee is 25% of past due benefits up to a cap of $6,000. So the most they can charge is $6,000, otherwise it's 25% of whatever your past due benefits are. The other type, when I say it's 95%, the other potential 5% is some attorneys will ask for a fee petition. And what that means is they're going to petition Social Security for whatever they think the cost should be. And what they have to do is they have to document how many hours they worked and the work that they did, and they're really asking for more than that fee agreement. And Social Security must approve that. You would get a copy of all that paperwork, and you'd be able to submit paperwork to Social Security if you disagreed with what the attorney was asking for. But you'd want to know up front, is it going to be that standard fee agreement? The other things you would want to look for, because you could say, are there hidden fees? Well, there really shouldn't be any hidden fees because everything should be up front. But for most, it's just that standard agreement. However, there's some attorneys that will charge you for medical records or that will charge you for travel if they have to travel to a hearing. Those would be considered out-of-pocket expenses, and they can charge for those separately than that standard fee agreement. So you would want to know if those are going to be additional charges that you're going to be responsible for, or if that's included in that standard fee.
Good points. I have been informed that there are some that classify a fee as an administrative fee that that varies, but so they're allowed to charge an administrative fee. I expect, correct?
You know, I'm not really familiar with a term of administrative fee. I guess they probably could. I have not seen companies that have done that, but those are definitely the questions to ask. If it's a fee that's not for the actual representing the claimant to get them awarded, then I guess they can charge for that because that is separate than what Social Security says their fee is for, which is the actual representation. So I think that they could do something like that. I'm just not familiar with companies that do that.
Okay. Well, this all has to be certainly weighed into the process of what's best for the claimant, the applicant, whether representation is the way to go or pursuing it or advancing their claim on their own. So you shared some really great information with us today. I want to kind of go through and recap and see if you could maybe pinpoint some of the key benefits that somebody would have if they're not represented now to what I would refer to as interview with a representative. What in your mind would be some of the key benefits that somebody would walk away from a free interview? And you've given them some of the questions to ask, but what can you share with us?
Well, I think that what you gain is maybe somebody with experience in knowing what Social Security needs to see to get you awarded, of telling you an honest opinion of what kind of case you have. Is it a good case? Is it going to be a tough case? And I think that's good for you to know the expectations going in, for you to have an idea to say, you know what, it sounds like I have a pretty good case, that my case is probably going to be awarded. And also give you that perspective if you hear, you know what, this is going to be a pretty tough one and this is why. So I think it can give you some good understanding into what Social Security is looking for and what you can expect is something that you certainly can gain.
Because they could say, listen, no, we can't help you. We were not able to accept your case.
Right.
Yeah.
If you hear that, then they're probably thinking you probably don't have a pretty good chance of being awarded, and they're not willing to even spend the time on it. That can be a tough thing to hear, but it also can be an eye-opener and help you set your expectations.
Sure, because if you file, you have to be below $1,000 a month in earnings. So if you're going to drop your income to file and wait around for a decision and you don't have a good crack at it, that'd be, in my opinion, that'd be very valuable information.
Right. And actually, substantial gainful activity, which is the amount of work that Social Security is considered substantial. You're not disabled. Right now, in this year, is $1,000 a month. So if this year you can work, there is a job that you can do that would allow you to earn more than $1,000 a month, then Social Security is going to say you're not disabled. If you can't find a job, you physically or mentally are unable to perform a job that's going to allow you to earn $1,000 a month, then Social Security should find you disabled. And that's the crux. If you want to get right down to the most basic thing that Social Security is looking for, that's what they're looking for, your ability to earn $1,000 or more in a month. If you're earning less than $1,000, you are still working, but you're earning less than $1,000, then you absolutely have a right to file for Social Security, even while continuing to work and earning that amount. Okay,
great. Okay, well, we've covered some super information here today. Is there anything that you think that maybe I've left out that would be of value to the members, Barb, other than what we've discussed?
I think what I'd say about a representative is what they're skilled at is they know how to communicate medical conditions to Social Security. They know how to cite why your restrictions and limitations prevent your ability to work. So they know the vocabulary. They know what has to be shown. They should take all of the work out of it for you because it can be an absolutely frustrating process to deal with Social Security. They're going to make sure nothing falls through the cracks. All the forms are completed, all the medical submitted. So the idea behind it is taking the work out of it for you and then giving you the best representation possible so you have the best chance of being awarded and being awarded quickly. Social Security is a long, arduous process, and a lot of people, the best chance of being awarded is at the hearings level. And sadly, by the time you get that hearings decision, you're very likely 3 years into the life of your Social Security claim. So anything you can do to try and get that claim awarded early, I think you should do, just knowing that that potential of having to wait 3 years could be out there. One other thing we didn't touch on is if you do go to the hearings level, a lot of representatives will try to get what's called an on-the-record decision. And an on-the-record decision means they're going to write up a legal brief and submit it stating all of the reasons why this claim should be awarded without the need to have a face-to-face personal hearing. And a lot of claims are awarded this way, and it's much quicker because you're not waiting for that hearing date. No one has to travel to a hearing. So it's all positive, and it's a way, to get an award. It's considered a hearings-level award, but it's quicker, and you don't have to actually go to a hearing. That's something that only a representative can do for you. And so, that's really important fact to know, and not only to know, but to ask your representative if they're going to try and write an on-the-record decision and get your claim awarded what's called on the record.
Excellent point. So is there like a general time frame that this would reduce the approval?
I'm just going to give you, nothing official. You're going to get off the top of my head thoughts.
Sure.
An on-the-record could shorten your hearing process from anywhere from 6 months to a year.
Okay, so if somebody's in the state of Georgia, which is like around 2 years for a wait for a hearing, it could potentially cut that time in half.
Yeah, absolutely. Absolutely could cut that time in half.
Right.
And that's a state where they have such a backlog with hearings is they want to award as many claims as possible on the record.
Mm-hmm.
They're trying to eliminate that backlog. This is actually a great time right now for on the records to be done because of all of the push right now to eliminate the hearings backlog. There is a great push to, if you have a good case on the record, award it.
Okay. Awesome. Bob, thank you so much. This has been fantastically valuable information. I've learned a lot. So I thank you for coming out and sharing this with us.
Great. Thanks for having me.